big picture, why e-discovery is important gets back to the two fundamental changes that people like me have seen in the course of our careers. Two big things have happened, and one of them has to do with the courtroom and the number of cases. We're now up to 18 million lawsuits filed per year. 18 million. We are an extremely litigious society. Good for us lawyers, I guess. But we're not really willing to do the funding to set up judges in a judicial system. So you're faced with 18 million lawsuits and the inability to have 18 million trials. It just can't happen. Plus, people file lawsuits just on a whim sometimes. You'll see. And a lot of these cases it takes $125 now, I think, in state court. You file a lawsuit. You don't even need a lawyer. If you file an affidavit showing you have no money, you don't even have to pay the $125. Impauperous proceeding. Had one guy once was known to have sued over 3,000 times. Martin Trigona. He sued every member of the Florida Supreme Court. Sued every judge in federal court in Orlando. I'm honored to say he once sued me. I met him once in court and said, "Hi, I'm Ralph Losey." He said, "I read what you wrote about me. I'm going to sue you." And he did. He never served process, though. It's funny, so I don't know if that counts. So anyway, 18 million lawsuits filed per year, and how many of them get tried? It's only 2% in federal court. I think it's a little higher in state court. 2% of the cases you're actually going to get that drama we were talking about of a courtroom trial. That means most litigation is not trial work. It is going through the procedures and the process of pretrial preparation, and that almost always includes discovery. That's why when you talk about litigation and you talk about trial work, really the trial work is just a little teeny 2% of it. Most of it is discovery. So that's one big change. The other big change is, remember these poor guys, remember the paper and plastic thing. RFPs, request for production. 30 years ago, everyone knew a request for production meant, I want to see your paper. Sometimes it was the tire actual things too, if it was some sort of negligence, but it meant produce the paper. 30 years ago, most companies, if they would have a nice orderly filing system, no one hardly kept their own files. They weren't their own record keeper. They were professionals that were hired to do that for you, and there would be nice discrete paper file of maybe a couple hundred. In the 80s, it got to be thousands of pages with the Xerox machine. It got larger, but they were fairly well organized paper files, and you could respond to requests for production without breaking the bank. But when we move from paper to plastic, the CDs, and we've talked about this before, the explosion of information, the Carl Sagan universe we're living in, where there's billions and billions of emails. It's as much information, bytes of information, as there are stars in the universe. And so, and everybody now is their own record keeper. Even senior shareholders in large law firms, they won't have somebody that's devoting their time just to file it. Why? I get 100 emails a day, and most of them are not properly filed, I'll admit. And I am a very organized person. Your average corporate businessman, it's chaos, and they get a lot of information, they can't find it. So the RFPs and the change from paper to electronic is the other major change that we're dealing with here. And that means that not only is discovery critical and important, but e-discovery, the electronic part, is important. So those are two kind of fundamental things you need to remember and understand.